much. For more reaction on this, we're now joined by legal expert Mpumelelo Zikalala. It's good to have you, and thank you very much for your time. I think the first and foremost area, before we come to this response now of the president and the issues that he's raising there, the big question that has been on my mind, and again, we've not really received direct answer to this, is this blanket certificate of non-prosecution that the former president says he received. So he initially had one that cited Billy Downer as who's been the person it was directed to, but later on it seems the NPA then issued another one that said, and everyone else that could possibly be involved in this case. How does that actually work? Does the everyone else really mean everyone else that you can think about at the time that you want to include in this matter?
I think the NPA is going to come back and say, we've made a blunder. In fact, it was a mistake. You can't really do that. Whenever that we say that you can't really prosecute a certain individual, every certificate must be suspect specific, because that's when you're going to sit down and then say, what are the charges that could be faced by Mr. So-and-so? What are the charges could be faced by the second person or even third accused? As the NPA, do we have appetite to prosecute this matter? Do we have enough evidence which is going to guarantee us a conviction? Is evidence so alarming and so blatant to such an extent that we are going to come back with a verdict that says you are guilty beyond reasonable doubt? Now, you can only do that when you do those individual merit assessment of those particular cases. Now, if you're going to provide a blanket prosecution status to an individual, you are doing something which is very reckless as the NPA and which shouldn't be done, because you are going to end up in situations such as these ones. So, meaning that if the president has a certificate that states that he can wake up tomorrow and then say, I need the deputy president, I need the minister to then come in, and any other individual that I might suspect to be part and parcel of this whole process. Now, then the second question would be, did the NPA do those individual assessments before the particular certificate was issued? The answer to that would be no. So you can see from this case that when you look at it, the real reason is that there's a blunder which may have been made by the NPA. I stand to be corrected on that one. And the blunder was that when they issued the certificate, they did not name the name of the suspect in which the certificate applied to, because that would have been the person in which the merits of this case would have been attended to or investigated. And based on the assessment of the NPA, they would have came back and said, we don't have any appetite to pursue any charges against these individuals, then you can go at it alone.
Yeah.
Unfortunately, it's only a court of law that can go to unravel or correct that particular mess.
Yeah. To borrow a little bit from theology, is then therefore President Zuma wrong to take advantage of this manna from heaven that seemingly has fallen on his lap?
Well, not necessarily, but let's remember that you have legal representatives which are going to assist you at the end of the day. And they would have done this process many times before, or they would, one, presume that they are well vested in this type of matters and how these particular processes should be. So that the other ones who are going to go to court and be able to argue it, or they must be able to argue it at the end of the day. But it's up to the one that has issued or made this blunder to then come first and then say, we've made a blunder such as this one, can you please withdraw that particular certificate, in which the NPA, by the way, has every right to do so. If you look at the Criminal Procedure Act from Section 8 up until 18, there are provisions that say at any time during the prosecution, you can withdraw the certificate and that's the end of the matter. So they could be the ones in which they could provide a real solution here between now and January 2023. Withdraw the certificate, issue another one which is suspect specific, and then everything is going to be fine. But if you are not going to do that, that's why we are going to have these processes that we have now,
yeah,
in which only the courts, or unless it's by mutual agreement, can be able to resolve it.
The state attorney seems to think they can write a letter and say, well, withdraw this private prosecution or otherwise face the consequences. What are the legal implications of that?
Well, it's up to the litigants in this matter at the end of the day. And when you propose something to me as the opposing party or the instituting party, it is up to me in my instructions whether I want to agree with you or not. If I'm not persuaded by what you are telling me and I still believe in what my rights are and the legal line that I've taken, I'm well within my rights to go to court and say, I'm not going to be told by you what to do. I'm going to listen to the court of law and the presiding officers who are going to tell me that I'm wrong. And it is only in those instances in which this particular letter is going to be withdrawn. So that letter to me, it's of, well, maybe a bit of significance because it would have placed whatever the president would have felt at that particular time, but it's not going to assist or persuade the president or the former president in terms of saying we are going to withdraw these particular matters and move forward. Maybe also in a question of cost at a later stage when they come back and say, we pre-warned you that you must remove this particular matter. It was not properly placed before court and you did not listen to us. Hence, we are going to ask for punitive cost because we wouldn't be here had you listened to us when we were pointing out all those salient issues relating to the deficiencies of the matter in which we are handling in this particular case. But for now, it has no force and effect at all. But what is alarming about it is the mentioning of the conference of the ANC which is taking place. Politics has no place in our law, and especially in this particular matter. In this particular manner, let me provide context to that. Yeah. The only manner in which the state attorney was supposed to respond to this particular matter was to say, stick to the legal prescripts that are there. Yeah. You have the constitution that protects the president's rights and also the manner in which these particular certificates are issued. This thing has nothing to do with any conference of the ANC. It has everything to do with compliance with the law and how private prosecutions are supposed to be handled.
So let's talk about that process and how these things are issued. The lawyers are seemingly raising issue with the fact that this was delivered at President Ramaphosa's private residence. So saying, well, it seems you are serving him as an individual and not him as the president. What's the distinction and how should that have been approached?
When it comes to the issuing, this is a prerogative of the NPA and how those are the custodians or the issuers of the certificate. How then it is served, it is purely on where you work, where your official residence is, or even your place of business is.
I'm referring to the summons now that have been issued to President Ramaphosa. The lawyers of the president are saying you've served this at President Ramaphosa's home, as opposed to serving him in his official capacity in the union buildings or wherever it is that you would serve him as the president of the country.
But the question here, because it's a criminal matter, so it's a person we must refer to as the accused, and it is an individual. So once a person who is referred to in the summons as Mr. Cyril Ramaphosa, it means that you must serve Mr. Cyril Ramaphosa anywhere where he works, where he lives, or where the address can be confirmed that you can be able to find him. So it's not necessary or there's hard and fast rule that if you want to serve the president of the country, then you must go and serve it in the union building, for example, or the presidency's office. It does not work that way when it comes to criminal matters. Another example would be if he would receive any criminal matter in which he needs to answer to in his personal capacity as he's been asked to do so now, or in his office capacity where it is involving him as an individual and not the office of the president. You will have to go and serve him where you can be able to find him. So it has no legal bearing whatsoever where he was served, or that it is important in terms of compliance with the rules, especially when he has to be called in to answer this particular allegation in January 2023, is that he must have been served at an address that he can be obtained or the address that he is using, and at the end of the day, that's what counts. What may be of importance, though, as a matter of defense, would be then to say, you are not dealing with a normal civil summons in this case. You are dealing with summons which are of criminal nature at the end of the day. Right. So I must be personally served as a person who's going to be an accused, and my rights in terms of Section 35 must be highlighted to me. So how can you highlight and read those particular rights to another individual and leave me out of the picture when I'm going to be the one who's going to answer at the end of the day?
Address the principle of miscitation and what do they call it here, non-joinder that they are raising here. What does it mean in principle without getting into the details because of time?
We are basically saying there's another individual that should be here, there's another litigant who ought to come and answer. You haven't joined them in this particular proceeding, so it's going to make the assessment of whether or the merits of the case, whether they are right or correct, a bit flawed. Can you please join them in or leave them out so that at the end of the day we can deal with litigants which are going to be able to provide a crisp answer in terms of the merits? I think in that particular case, I would have been referring to the Minister of Justice or even the NPA at the end of the day, who are part and parcel of these processes, or the individuals that ought to act in instances such as this one. So they're basically saying you should have joined these individuals, make sure that you do so. And a perfect opportunity to answer or to raise those particular points is when you go to court in January, it must form part of your defenses of why the matter should then be removed from the roll, or the defenses of why the matter, or you should win the match at the end of the day, if at the end of the day it continues.
Cyril, much appreciated. Thanks so much for coming on. Legal expert there, Mpumelelo Zikalala, always clear, concise, and explaining these matters of law for us.